Hey guys, you may have seen my earlier video on the top 5 most misunderstood contractual clauses. In this second video, I will clarify another 5 more. First up is the non-compete clause. People often misunderstand non-compete clauses as a blanket restriction on their right to work. While these clauses limit what you can do after the contract ends, they have to be reasonable in scope, meaning in time, geography, and industry. Another requirement for such clauses to be valid is that the other party, usually the company or the employer, has a legitimate proprietary interest to protect, such as customer lists, supplier lists, trade secrets, secret recipes. If the non-compete clause is drafted too broadly, a court will deem it to be unenforceable. If you're agreeing to a non-compete, ensure that its restrictions are reasonable and necessary to protect the other party's legitimate business interests. Next is the entire agreement clause. This clause states that the written contract is the full and final agreement between the parties. Many understand this to mean that verbal promises or earlier drafts count, but they don't. This clause effectively wipes the slate clean of all prior negotiations or side agreements unless they are explicitly included in the final contract. Make sure everything that you agreed upon is written into the contract, because the entire agreement clause will prevent you from relying on anything outside of it, such as verbal discussions, WhatsApp, or emails that occurred before the signing of the contract. A third often misunderstood clause is the assignment clause. Assignment clauses are often assumed to mean that either party can freely transfer their rights or obligations to a third party. But these clauses usually require consent from the other party before any assignment can occur. Always check whether the assignment clause permits free assignment, or if consent, usually written consent, is required, especially if you're planning to hand off the contract to someone else down the line. The fourth clause that I will discuss is the time of the essence clause. This phrase makes people think deadlines are merely suggested. In fact, a time of the essence clause means that if deadlines are not strictly met, the contract could be breached. If you miss a deadline, even by a little, you could face serious legal consequences. Treat deadlines seriously when you see this clause. Any delay could be considered a material breach of contract. The last clause I want to talk about is the governing law and jurisdiction clause. Many parties overlook this clause, thinking it's a standard formality. However, it's incredibly important because it dictates which country's laws will apply if there's a dispute, and which courts have the authority to settle it. For example, a Singapore company might find itself in a US courtroom if they overlook this clause. Always check that the governing law and jurisdiction is favorable to you, and that you are comfortable litigating under that system if a dispute arises. You can watch my earlier videos on cross-border contracts and arbitration. That's all for today, folks. Thank you for watching. Don't forget to like, share, and subscribe, and I'll see you in the next video.